Today, Alice and I would like to talk about Davies-Gilbert and Goacher, which is an important recent case decided earlier this year about restrictive covenants. Common situation where you've got a restrictive covenant restraining any building on land without the consent of the covenantee and his successors, that consent not to be unreasonably withheld. As you may know, there was quite an important case that I was involved in fact, last year called Hicks and 89 Holland Park Management that considered that issue, in particular in the context of the extent to which you could take into account aesthetic considerations in refusing consent. We've got another really important case on the subject, which has gone further in the analysis of all that. Alice, can you maybe take us through on what it decided and what the important points are that arise from that?
Yeah, so in terms of the facts of the case, the claimant is the estate manager and or owner of the Gilbert estate, which is in East Sussex, in and around a village called East Dean. And his predecessors sold off various parts of the land subject to the restrictive covenant that you mentioned, John. And the defendants owned 2 parcels of land that were subject to this restrictive covenant. And they wanted to build, as part of a scheme, 2 detached houses on their respective plots. So they go to the claimant and they say, can we have your permission to build these houses? And they set out the details of the scheme. And the claimant says no for 2 reasons. And those 2 reasons that he gave were, 1, the amenity value of the estate as a whole, and 2, the future use and commercial value of the adjoining land. And that distinction, I think, is quite important. Mm-hmm. It comes up later. And then down the line, he actually goes back and says, well, there are also various considerations that I took into account as well as those reasons that I gave you in writing. And so it's a slightly odd situation in this case because the defendants then start building, at which point the claimant goes and gets an interim injunction, which is why we've got the claimant as the decision maker rather than the applicant. And so the question before the court was it reasonable or unreasonable for the claimant to have withheld consent? So, John, as you mentioned, there was this issue of the aesthetic considerations. I don't know if you want to.
Yes, I mean, I think that's. This was in Hicks and 89 Holland Park. This was a difficult matter, and the inherent nature of the problem is how do you adjudicate whether an aesthetic consideration is something you can legitimately take into account or not? You know, to what extent is it reasonable or not reasonable? How do you adjudicate on questions of taste? Mm. So what that case said, and also Davies-Gilbert and Goacher is really saying a similar thing, which is it's not sufficient just to say, I don't like it. There's got to be something more than that. There's got to be some rational reason behind it. So one of the interesting things on that case was there were expert evidence on both sides about the question of the character of the building and the loss of the amenity that might be caused by it. But also, interestingly, as I'm afraid often happens, the experts kind of got into the fray and took sides on behalf of their respective clients. And the judge was pretty forceful on that being a wrong approach. Isn't that right? Yeah,
it makes some salutary reading for expert witnesses because, as you say, the judge was deeply concerned by the fact that actually in this case the experts became quite partisan and quite impassioned about this Sussex style, which was a big topic in this case. And actually I think where you are going to instruct experts, it's just probably a good place to start in terms of reminding yourselves and your experts exactly what they're there to do, which is to answer the questions put by the court, to take into account all relevant factors and not to sort of skirt around or avoid issues that don't necessarily help your client's perspective.
Yes. We maybe need to get back to the decision on the case. I'm not sure we dealt with that, which of course those aesthetic considerations were held to be reasonable on the facts of that. So it was right that you could take into account the effect on the retained land. But the first reason, looking at the effect of the estate as a whole, was held not to be a legitimate reason because that went beyond what the purpose of the covenant there. Yeah. So the first reason was struck down. The second reason was adequate, was not. The I mean, a couple of things that are not particularly news. Burden of proof on the covenantor remains on the covenantor throughout.
Yeah, because in this case, the defendants tried to argue that once you'd established a prima facie case that the refusal was unreasonable. Sorry, once you'd established a prima facie case to say that that refusal was unreasonable, that the burden would shift. However, the court said no, there's no shifting of the burden of proof. What happens is it's for the defendants to prove.
Yes.
And if they do so, then they win the answer. They win the case. But the reason that the defendants had tried to establish this kind of shifting was in reliance of this R.M. Cole and Russell case, in which the tenant had argued that trying to assign a lease to a assignee who was respectable and reasonable, they'd established that the assignee was respectable and reasonable and therefore shifted the burden of proof. That was quite a different setting to this one.
Other thing, I mean, lots of other things we're getting out of this. One of them is there was an idea in Hickson 89 Holland Park that if it would be unreasonable to withhold consent subject to conditions, then unless the covenantee suggested those conditions, it was unreasonable in giving an outright refusal. And in this case, Her Honour Judge Claire Jackson, who was the judge, said, no, that's not right. I don't agree with Judge Pelling in Hickson 89 Holland Park. And it's for the covenantor to suggest, for the applicant to suggest those conditions. If it doesn't suggest those conditions, then the covenantee can just say, if it would otherwise be reasonable to do so, I refuse consent. So that's an interesting.
And I think going forward, I mean, the judge made it pretty clear that actually in this case, the defendants could essentially have a second bite of the cherry, because if they went back and looked at the refusal and if there was scope to make alterations or additions that would neutralise those conditions, you could simply reapply for consent on that basis. So it's not the end of the story if there is that scope.
Yes. Other things we get, again, not news. If you've got some good reasons and some bad reasons, then as long as the good reasons were sufficient on their own to justify the decision, then that's okay, that's still reasonable. But then to my mind, I don't know what you think about this, Alice, but to my mind there was some confusion, because a distinction was made by the judge between considerations that you take into account and considerations that contribute to reasons for the decision. Yeah. And to my mind, she made that distinction in a number of places. I don't quite get that to my mind. If there are things you take into account, then they must at some level be operating in your decision-making process, I would have thought. Yeah,
there's some quite interesting discussion. I think it's paragraph 64 that's a really good place to look for this discussion by Her Honour Judge Jackson of what are reasons, what are considerations. She's at pains to say that there's no magic in the language of reasons, and she draws out various different language that's used throughout the case law, which are all synonyms for reasons. But as you say, she then sort of draws this distinction between considerations that feed into reasons, but some considerations that don't necessarily feed into the reasons. And so I think really what the parties are left with is having to stand back and say, on a Braganza analysis, was the decision-making process reasonable and was the outcome reasonable? And it's interesting, isn't it, to see this Braganza analysis coming into another context of land law.
I agree. And the other thing I thought interesting was there was a really clever argument in relation to the first point where the decision was held to be unreasonable because it was looking not just at the benefited land, but at the estate as a whole, which included the benefited land. The argument was made, well, that's okay, because you, the judge, then need to analyse whether the reasons relating to the benefited land were alone sufficient to justify the decision. And the judge, I thought, what a clever point, but the judge quite rightly said, look, I'm not getting into those what-ifs there. Yeah. I'm not reconstructing your reasoning. Yeah. Your reasoning was in relation to the estate as a whole. You're not entitled to look at the estate as a whole. Yeah. And so, therefore, that reason can't stand up.
And actually, I think this case is quite a good example of why it's really important to set down your reasons very clearly at the material time,
Yes.
because the judge really stresses the fact that the court will not go back. If you find a good reason down the line, the court will not go back and rewrite your reasoning at the time. And so where there's some doubt, or perhaps there's a number of reasons and you're weighing up the respective benefits and force of those different reasons, that's probably the time at which to take legal advice, because putting together a really solid account of those reasons at the time is actually going to save you a lot of time and energy down the line, isn't it?
I agree. I think the only other thing we need to talk about is this agreed statement of law.
Yeah.
So this is a curious notion. If you get the judgment, there is, I think it's 26-page appendix at the end, which is an agreed statement of the relevant law, agreed by the respective counsel on the case, and that was done pursuant to an order made by, I think, Master Schumann at some interlocutory stage in the proceeding. I've never seen that before, have you?
No, I've not seen it, and in fact the judge, I think, was surprised to see it, but very grateful indeed. It's an interesting idea, isn't it, getting the parties and particularly their legal team to pin their colours to the mast in terms of what they're saying about the law. And in fact the statement itself is an interesting read, because there are sections in which they say, well, the claimants say this and the defendants say this.
Yeah.
And so it sets out very clearly for the judge where the battleground lies in terms of the legal framework. But as you say, it's a really hefty document and must have taken quite a while to put together.
Maybe I'm just being a bit old-fashioned about this, but my fear is it's going to take a lot of time and involve a lot of cost to do this. So you can see the temptation for judges to do it. Oh, it's going to save us time. But the reality is, I'm afraid, with a lot of those initiatives that are on the face of it there to save time, actually cost more time and more money to deal with. So I'm hoping that this is the exception rather than the rule, or else we're going to be spending our lives negotiating agreed statements of law before cases.
Yeah, there's some other good tips, I think, for litigants in this case, in terms of firstly thinking about how many applications you're making, because in the Hicks case, it was 2 covenants, wasn't it, and treated as 2 applications. Whereas in this case, there's 2 plots of land, 2 defendants, but treated as 1 application. So it's worth thinking from the start how many applications you are actually asking the court to consider.
Yeah, I suppose if you're the applicant, you want it to be dealt with as separate applications. And I think it's a straightforward question of construing the application. So you look at the application, is it on its face, albeit in one letter, 2 different separate applications? I mean, simply one sentence at the bottom of the letter saying, please treat these as entirely separate and independent applications would do the trick, wouldn't it?
And luckily for the claimant in this case, the 2 reasons were treated as freestanding.
Yes,
so as you say, the second reason could succeed.
So, okay, this is it's if you like only a first instance judgment, but I think hugely interesting. Lots of practical advice comes out of it. Another useful application of this really difficult area about the application of these covenants, especially when you've got aesthetic considerations in mind. So definitely worth a read, very well reasoned, very well argued, I think it would appear on both sides as well.